Welcome to today's Explainer. We're jumping right into the shoes of a first-year law student to unpack the seriously fascinating rules governing neighborly disputes and property rights. If you've ever wondered exactly where the legal line is drawn between peacefully enjoying your own backyard and dealing with a neighbor's totally disruptive behavior, well, you are in the perfect place. Today, we aren't just looking at the law, we're looking at how lawyers actually learn the law. We're going to experience the journey of extracting real binding rules from historical court decisions. Let's dive in.
Here is our syllabus for today's class. We'll hit the importance of case briefs, get a quick overview of nuisance law, and then jump right into particles and trespass, public nuisance codes, and aesthetics. Finally, we'll wrap the whole thing up by creating our black-letter law cheat sheet.
Starting off with Section 1, the importance of case briefs and extracting the rules.
You know, when you walk into a law school classroom, nobody hands you a simple, bulleted list of rules to memorize. Nope. Instead, you're handed hundreds of pages of past court decisions. But we don't just read these court cases for the drama. Though, to be fair, these disputes between neighbors can get pretty incredibly dramatic. We read them to pull out the actual actionable rules of law that govern our society. This is what legal professionals call black-letter law. It's the skill of looking at a super specific scenario, like, say, a 1905 copper smelter blowing smoke, and figuring out what universal legal rule the judge applied to solve that exact problem. And as we go through our assigned cases today, that is exactly what we're going to be doing, hunting for that black-letter law.
Moving on to Section 2, Overview of Nuisance Law, the foundation. Before we analyze the specific cases, we absolutely must understand the core difference between these two concepts. Trespass is all about someone breaking your exclusive possession, whereas a private nuisance is about someone unreasonably interfering with your ability to actually use and enjoy your land. Think of it like this. If your neighbor builds a physical fence 3 feet onto your property, they've invaded your exclusive possession. That's your classic trespass. But if that same neighbor stays completely on their side of the property line and decides to blast heavy metal music at 3 a.m. every single night, well, they haven't physically invaded your land, but they've definitely created a substantial interference with your use and enjoyment of it. That right there is a private nuisance.
All right, Section 3, Particles and Trespass, featuring the Bradley case.
Our first reading assignment has some pretty fascinating facts. Picture this. We have a primary copper smelter in Tacoma, Washington that's been operating since 1890. Fast forward a bit, and some 4 miles away on Vashon Island, property owners sued because the smelter was emitting these microscopic particles of arsenic and cadmium that were just blowing right onto their land. Now, before reading the brief, our professor gives us a fantastic tip. Look specifically for how the court compares these two legal theories. This is a crucial strategy for any law student. You always want to know what you're hunting for before you read the text. Here, we're looking at that blurry line where an invasion isn't a solid object, but rather a microscopic, non-physical entry. So the court is staring down this exact question. Can invisible particles from a smelter settling on an island be considered a trespass, a nuisance, or both? Remember, we are talking about particles that literally cannot even be detected by human senses. Normally, we think of trespass as a person walking across your lawn, right? Not a microscopic speck of cadmium landing in your soil. And the court says, yes, they ruled that because the smelter operator knew way back since 1905 that the wind would blow particles there, the legal intent was met. And because those particles accumulated, it counts as both a trespass and a nuisance. Let's break down the court's rationale here. They decided that if airborne particles are just transitory, meaning they blow through and quickly dissipate, that's simply a nuisance. But if those substances actually accumulate on the land and stick around, that crosses the line into a trespass. Importantly, the court noted that trespass and nuisance are not mutually exclusive. They can absolutely apply concurrently. However, and this is a big however, to prevent every single landowner within 100 miles of any factory from suing, the court established a strict rule. You must be able to prove actual and substantial damages to your property.
Up next, Section 4, Public Nuisance and City Ordinances in the Cruz case.
We're shifting gears now from private disputes between neighbors to disputes involving an entire community. The professor's note focuses our attention directly on how local city codes interact with the legal definition of a nuisance. In this specific case, an individual attempted to open a medical marijuana dispensary in the city of Claremont. The city denied his business permit because at the time, that type of business wasn't an enumerated use in their zoning codes. But despite the denial and repeated warnings, the individual just went ahead and opened a business anyway.
So unlike a private nuisance between two specific neighbors, a public nuisance affects a considerable number of people in a community all at once. It could be something injurious to health or maybe an obstruction to the free use of property. But the Cruz case introduces this fascinating legal shortcut that cities can use to define a public nuisance. The core legal question in Cruz's is pretty bold. It asks if simply operating a business without the proper city permits automatically makes it a nuisance, completely regardless of what the business is actually doing on a day-to-day basis. The defendant argued that the city failed to prove his business caused any actual harm to the community, which, as we know, is normally a strict requirement for a nuisance claim. Looking at the court's rationale, they laid out a really clear three-step logic. Because the city code expressly prohibited operating without a license, doing so was automatically a nuisance per se. This meant the city didn't need to prove any actual harm occurred at all. This is a massive takeaway for our law student notes. A nuisance per se happens when a legislative body exercises its power to explicitly declare that a certain activity is a nuisance just by its very existence. If the law expressly declares it, the court says no further inquiry is needed. You don't have to prove noise or smells or traffic issues. The mere fact that it violates the municipal code makes it a public nuisance that can be shut down immediately.
All right, Section 5, Aesthetics and Property Values, the Myrick case.
Okay, but what happens if your neighbor does something totally legal but, well, incredibly ugly? The professor challenges us here to figure out if an ugly view or a drop in your property value is enough to actually sue your neighbor. In this case, landowners in Vermont sued two solar energy companies because their neighbors leased property to construct massive commercial solar arrays. The plaintiffs claim these arrays ruined the area's pristine rural aesthetic and caused their own property values to tank.
The million-dollar question, literally, for these homeowners is this. If your neighbor installs commercial solar panels that you find incredibly ugly and it lowers your home's value, is that a legal nuisance? Is the sheer unsightliness of a thing enough to drag someone into court? The court actually draws a really strict line here. They compare mere emotional distress over an ugly sight to an objective interference with how you actually use your land. The court noted that there is a huge difference between, say, solar panels casting blinding reflections into your bedroom window and keeping you awake, which is an objective interference with your use of the property, versus you simply not liking how the panels look. Being frustrated by an unattractive view is classified by the court as emotional distress. It is not a property interference.
And the court's answer is a hard no. Aesthetic preferences are just way too subjective to regulate, and you can only claim a drop in property value as damages if a separate, actual nuisance, like chemical contamination, is already proven. The court's rationale here is incredibly practical. If courts allowed lawsuits based on pure aesthetics, it would create total chaos. I mean, what one person finds beautiful, another finds hideous. As the court pointed out, it would be a two-way street. Sure, you could sue a neighbor for building an oddly shaped house that lowers your property value, but a neighbor who built a palatial estate that increased your property value would have no way to demand a cut of your profits. Therefore, Vermont upheld its 120-year-old rule: aesthetics alone cannot be a nuisance.
Finally, Section 6, Black Letter Law Rules, your exam cheat sheet.
We finished all our reading, so let's synthesize this whole explainer into our final exam cheat sheet. This is where all those dense case briefs finally pay off. We've extracted the core principles and can now map them out perfectly. We know now that private nuisance requires an unreasonable and substantial interference. Public nuisance scales that up to affect a whole community. And nuisance per se, that's the legislative trump card, bypassing the need to prove actual harm because the activity is expressly forbidden by law.
To cap it off, here's your ultimate black-letter law rule for private nuisance. The interference must be definitely offensive to a normal person in the community, impacting the actual present use of the land, not just their subjective aesthetic tastes. You can't be overly sensitive here. The law judges the interference based on what an average normal person would find definitely offensive or annoying.
As we wrap up this explainer, I want to leave you with something to ponder. If aesthetics aren't a nuisance, just how wild could you legally make your own backyard? Think about it. As long as you aren't emitting toxic particles, violating city ordinances, or creating objective harm like noise and light pollution, the visual canvas of your property is surprisingly unregulated by nuisance law. I hope this journey through a law student's syllabus has given you a much clearer understanding of how we balance property rights in our communities. Thanks so much for joining me on this explainer, and keep questioning the rules around you.